Okay, so we will see some topics from Unit 4. Okay, precedent we have. Then we have kinds of precedent, certain factors which will strengthen a precedent, which will reduce its authority. All that part we have in Unit 4. Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. Okay, so what is precedent?
Previous cases used in the present judgment.
Yes. Previous cases used in present cases that are there before the court. So judicial precedent, it refers to previously decided judgments of superior court. So superior court, whatever has previously been decided, rather than considering the same things again and again, we can take reference of it unless and until there is some problem with the decision or something, we can refer that same decision to save time. Such as high courts and supreme courts. Decisions of high courts and supreme courts will be binding on its subordinate court, which judges are bound to follow. This binding character of previously decided cases is important considering the hierarchy of courts established by legal system of a particular country. Because we are saying that Supreme Court is like the apex court, topmost court in India. After that, we have high courts, and subordinate to these high courts, we have again all these subordinate courts divided in civil and criminal classification. Right? So considering that it is having like a set hierarchy, it is very important that decisions of higher courts are followed by its subordinate courts. And this hierarchy, when we talk about India, it is established under Constitution of India itself. When you look at the Constitution of India, you will see that it talks about a lot of different provisions. And there are two specific parts dealing with central as well as the state government. Central is part 5, which is the union. There we have again 3 organs: executive, we have legislature, and then we have judiciary. When we talk about judiciary, it makes provisions relating to Supreme Court. Right? Same ways in part 6, we have provisions relating to state. Again, we have executive, legislature, as well as judiciary. When we talk about judiciary, we have high courts as well as we have the subordinate courts, like the list that we saw in the other class. Hierarchy of courts in India. This hierarchy we get provisions under Constitution of India. In detail, it mentions everything. Okay, now when we talk about a decision, okay, one particular judicial decision will have 2 different parts in it. One is ratio decidendi and another one is obiter dicta. Ratio decidendi is nothing but the reason for the decision. When we take the example of a judicial decision, even though it is given by a judge, that decision has to have a reasoning also. Have you read any judgments or seen any judgments? Anyone have?
Yes, I have.
You have seen?
Yes, ma'am.
Okay. So what all things did you notice in the judgment?
Ma'am, first I think there was a fact, some given in the judgment.
Hmm.
And ma'am, then there were like sections mentioned on which the topic or like the case is about. I just read one. I didn't read that the whole judgment, but I read the Shankari Prasad cases judgment. So it was like the articles which were involved were written in that.
Yes.
That was there. And then one party responding is also there in the beginning.
Yeah. So when we look at a judgment, any judgment for that matter, we see a lot of things. Any random case, you can just open India Kanun, you usually get the judgment. Okay, so there we get some details like which court it is, who all were the judges who decided the case, case number, what kind of a case it is, from how it is coming to this particular court. It would have like a brief on what happened, like you said, brief fact of the case would be provided. Okay, then it will have what were the issues before the court, what court had to decide, like what was the basic question in front of the court. Okay, and while giving this decision, right, court will decide something, it has to be reasoned decision, like we say, right, reasoned decision. So what is reasoned decision? It is nothing but that court would give some reasoning. Okay, usually when you look at a judgment, right, you would see, say, court will say that in this case, the court observed, this is what was held in a certain case, right? Similarly, a lot of cases reference would be given. They will mention certain sections, certain articles and all that also. Okay, that means they are saying under so-and-so provision it happens, under this case, this kind of a thing was held. Because of all these reasons, we are coming to this conclusion and we are giving a decision like that. That is nothing but reasoning. They are justifying why they have given that decision. Okay, that part is called as ratio decidendi, which is a very important part in a judicial decision. It also has something called as obiter dicta, which is like a general observation of the court. Okay, while giving a decision, court might make some general observations. Okay, let's, there was another case. Okay, sometimes what happens, right? Take for example, while giving a decision, right? The Supreme Court may observe that what is happening is that police officers, okay, or any department for that matter, is not performing their duties properly. Okay, so in such a case, court might say that we have observed that police officers are not been given proper training before joining their services to understand how sensitive a matter is, how to deal with it and everything. Okay, so that is nothing but a general observation. Court has given a certain decision. In that same decision, court might say that there is, in general, lack of training for the police officers. Okay, so that we should be giving. That would be nothing but a general observation. So what is general observation now? Like that, court may say that while deciding the case, court might just make a general observation that in general, there is lack of training given to police officers might be. Okay, or in general might be these kind of a thing should be done. Okay, like in deciding a case relating to child labor, court may make a general observation that because free and compulsory primary education is not working that good in India, that's why child labor is still existing. Okay, these are nothing but general observation. Court has just made an observation. It's as such not that important as compared to ratio decidendi, but again, general observations are also important. Depending on those observations, some steps might be taken that in so-and-so case, court had observed like that. Maybe we need to improvise on the free and compulsory primary education that we are providing. Okay, so they are important, but ratio decidendi is more important because whenever a decision is given, we need to justify that decision as well. Okay, so there are two different types, like two different parts which we have in a judgment. Whenever you are reading a judgment, you can try to observe, is there any observation, is there any obiter dicta that court has said, or what is the ratio? You can try to see. And when you look at foreign judgments, right, in case of India, you would see like 5-6 judgment or 10-12 judgments might be referred. There, in case of foreign judgments, right, sometimes it happens like pages after pages, they are simply referring to previous cases. In this case, it happened, that case, it happens, 100, 200 cases also, it might be referred in one single case. Okay, so these are again very important things. again, you would see, okay, whenever you are opening one particular case, right, in which all cases this particular case was cited, that also you get. See, cited 62 documents, as in 62 different cases, this case was cited. What was held in this case, that was referred, and after that a decision came. All these would be again related cases. Like this one related to Article 368 and our fundamental rights and everything. All these are also related. These are nothing but, again, concept of precedent itself, right? One case can be referred again and again. Now, who is following whose decision? Okay, in India, we say that Supreme Court of India is like the apex court, topmost court, highest court. So Supreme Court of India, which is established under the Constitution of India, okay, in the hierarchy of courts, it is the topmost court, followed by high courts at state level. Supreme Court, then we have High Court, and below that we have District and Sessions Court, and below that we have all the lower level court, magistrate court, district, municipal court, small causes and all that. The structure of judiciary in all states is almost similar, with a little variation in the name and designations and everything, but otherwise they are almost same. Under the mentioned hierarchy of courts, the decisions which are given by Supreme Court are binding on all courts throughout the territory of India. It is important to note that Supreme Court is not bound by its previous decisions, which is an exception, with an exception that smaller benches are bound by decision of larger benches, and that is co-equal benches. So if a decision is given by Supreme Court, as such, Supreme Court is not bound by its own decision because it's at the same level. But in case a decision is given by 5 judges of Supreme Court, it will be bound on lesser than 5 number of judges, it would be bound. Okay, so we would take into consideration the bench that has given the decision. Okay, so Supreme Court will be bound by its own decision only if it is given by a larger bench. To a smaller bench, it would be binding. Otherwise, Supreme Court's decision will be binding on all courts across India. While the decision given by high courts are binding on the subordinate courts within the jurisdiction of that particular high court. One high court has given a decision, all the subordinate courts that are coming, take for example, High Court of Karnataka gives a decision. It will be binding on all its subordinate courts. All the subordinate courts that are there in India, it will be binding. Okay, take for example, recently that wearing burqa in like schools, right? Along with school uniform, it should be allowed or it should not be allowed. Karnataka High Court said that it's not like a mandatory part of religious practices. So it is not, like they can skip that, they can wear the normal uniform. When Karnataka High Court has said like that, it becomes binding on all the subordinate courts. If another person files similar kind of a case in a subordinate court, okay, in a magistrate court or something, it would be bound to follow that particular decision. But Supreme Court is not bound. If these people challenge that decision in Supreme Court or somebody else reaches the Supreme Court may give a separate decision also. Supreme Court may say that, okay, fine, there is no harm in wearing a burqa. If somebody wants, they can wear it. That means Supreme Court is free to give a different decision, but all the lower level courts who are coming under Karnataka High Court, they would be bound to follow this decision. Okay, now take for example, Karnataka High Court has said that burqa you cannot wear in a school because there is already a uniform. Okay, that is given by Karnataka High Court. What if similar kind of a case is filed in Tamil Nadu? Okay, Tamil Nadu High Court. In that case, Tamil Nadu High Court is free to give a decision. Tamil Nadu High Court, if it feels that, okay, Karnataka High Court was right in its decision. Okay, there Tamil Nadu High Court can also stick to this decision that Karnataka High Court has said like this, and this is the reasoning given by them. We agree to them, so we are also saying that burqa should not be worn along with school uniform. But Tamil Nadu High Court is not bound. If it feels that no, what is wrong in wearing a burqa, they can give a decision against it also. They can say that, okay, Karnataka High Court feels like that, but we think there is no harm in wearing a burqa, so it can be worn along with the uniform. Okay, that means in case a decision is given by one high court, it would be bound on its subordinate courts within that state. But for another high court, okay, it would have persuasive value. As in, if you feel that is a good decision, you can consider it. If you think that is not a good decision, you can give a decision against it also. It depends on you whether you want to follow it or not. Okay, is it clear, or you want another explanation or example?
It's clear.
Clear, right? Because it's an important part. Whose decision is binding on who? Okay. Otherwise, it's yeah.
Please give another example.
Okay, another example for entire thing or for high court?
Just for high court.
Okay, fine. Fine, I'll give another example. Take for example, Supreme Court clear, right? Are you sure?
Yes, ma'am.
Okay. So take for example, you are a judge in Karnataka High Court, okay? And I am a judge in Tamil Nadu High Court. And another one is a judge in Punjab High Court, okay? Now you have given a decision that this particular thing is wrong, okay? You have said that maybe wearing burqa should not be allowed along with school uniform. Similar kind of a cases filed in my court also, Tamil Nadu High Court. Because high courts are at equal level, right? Where Karnataka High Court stands, Tamil Nadu High Court also stands at the same level. Same way Punjab High Court also stands. So in such a case, I am not bound to follow your decision. Your decision will have persuasive value. As in, if I feel that is okay, I can follow it. If I feel that is not a good decision, I can completely ignore that, give a completely different decision also. Okay, high court's decisions are not binding on other high courts. But if judges want, they can refer it, they can follow it, no harm in that. High courts are free to see whether they want to follow another high court's decision or not. But Supreme Court's decision, it will be binding on all three of us. Karnataka, Tamil Nadu, Punjab, whatever high court, it would be binding. But for another high court, we have the freedom to see whether we want to follow it or we don't want to follow it. Okay, but whatever decision is given by Karnataka High Court, it will be binding on all its subordinate courts. Okay, all the magistrates court, sessions court, district court, court of small causes, municip, whatever courts are there in Karnataka. Whatever courts are coming under Karnataka High Court, they will have to follow that decision. Okay, but if Tamil Nadu High Court gives a different decision, all the subordinate courts coming under Tamil Nadu High Court, right, Madras High Court, they would be bound by it. Okay, Tamil Nadu High Court, if it says something, all the district court, sessions court, magistrate court, everyone will have to follow that decision. So High Court's decision are binding on its subordinate courts, right? Because every single state will be having their own different courts. They are bound to follow whatever their superior, their High Court has said, not other High Court. Okay, is it clear now?
Yes, ma'am.
So this part, yeah.
Yes, ma'am. Ma'am, actually, I have one doubt. What about the cases from like other countries? For example, I think there's a case called the Neil case.
Cases from?
Ma'am, cases from other countries.
Okay, yeah.
So, ma'am, there is a case called Neil case in Torts, I think. And ma'am, we give example of that case very often. So, like, are those cases persuasive? Like, how persuasive they are? Like,
okay.
Comparison to Indian case.
Okay, that's nail in beer bottle you are saying, right?
Yes.
Okay. Yeah. So see, there are certain things like, take for example, when you read contracts, sometimes you get foreign cases when you read torts and all, right? because we have borrowed it from a foreign country, right? From England, we have borrowed the concepts. It has developed there. So mostly when you are reading law of torts, you would see a lot of foreign cases are there because the concept originated there. From there, we have borrowed it. Okay. Same ways in case of other subjects also, like international law, in case of contract, in case of many other things, you would see reference of foreign cases. All right. Now, why we have given reference of a foreign cases might be because a certain concept developed there. Okay, like take for example, if you are reading mental shock, it is a concept which developed in a foreign country. From there, we have borrowed it. So in such a case, we give reference of that case from where it originated, or might be one case which has given some, like landmark findings on a certain thing. We do refer all those cases. Like basically, it's like we have borrowed the concept as such. Okay, but we can make our own changes also. Like if when you study law of torts, right, you would see there was a concept of strict liability. Okay, it was developed in a foreign country, in a foreign case that we adopted. That means when we accepted it, it became binding. Okay, that particular concept became binding on us. But then Supreme Court said that this concept is not working well. Let us make some changes and develop one new concept altogether, which is absolute liability. So once Supreme Court says that this foreign concept, which we have been following for all this while, we are making some changes, then this becomes binding. Whatever Supreme Court of India has said, that becomes binding. But until that point in time, if we have accepted something, that becomes binding. So mostly it happens that Supreme Court might, like courts also refer to foreign decisions while giving their judgments. Okay, if something is established in India by Supreme Court of India, High Court should not refer to what foreign court has said, but they would refer to what Supreme Court has said. Okay, but yes, in some matters they can refer that, okay, in foreign country this kind of a concept has developed, we can also accept. Not many times you would see examples of such foreign cases whereby we have taken some kind of concepts. Okay, there is a concept called prospective overruling, as in we are overruling a decision, but from the coming times, lot many concepts you would see we have like taken from a foreign country. So it depends how that concept came. Okay, it might happen that Supreme Court acknowledged that yes, this is a very good concept, let us make it applicable. In such a case, it would have a binding effect. Otherwise, Supreme Court is also free to make some changes, that maybe this concept we need to make little bit changes, that way it becomes applicable. Okay.
Okay.
So that is nothing but like a foreign decision. It is having a lot of importance, but again depends how it is made applicable. Okay, now another thing that we have is kinds of precedent. Okay, now we know what is a precedent, but what are the different kinds of precedent? There are mainly 4 types of precedents: original precedent, declaratory precedent, authoritative precedent, persuasive precedent. Okay, and authoritative precedent is divided in 2 types: absolute authoritative precedent and conditional authoritative precedent. So we will see what these different types are. First one we have is original precedent and declaratory precedent. Now, what is declaration? Declare something.
Kind of an order.
Sorry?
Kind of an order that the Supreme Court declared something. So it's kind of an order.
Okay. So original as in something which is coming for the very first time. Okay. Declaratory as in declaring something. Maybe it's already there, but it's done. It is declared properly. Okay. That is what this precedent is all about. So original precedent is where judges create a new law and the same becomes binding, a completely new concept they might bring. That is nothing but original precedent. For example, in India, we were not having any legislation or scheme to deal with witnesses protection. Okay, witnesses who come forward to give their statements, they were not getting any kind of protection. We were not having any kind of legislations. So Supreme Court of India, in one case, they introduced something called as Witness Protection Scheme 2018 and made it binding in entire India. So this will be nothing but an example of original precedent, that this concept of witness protection itself was not there in India, Supreme Court introduced this concept. This is nothing but original precedent. Okay, this concept only was not there. It was brought by way of a case. When we talk about declaratory precedent, that means the concept is there. It's just that nobody has spoken about it. Okay, like making it very clear, nobody has made that, but concept is there, hidden somewhere. Okay, take for example, declaratory precedent is where a known or established law is applied to a particular facts of the case. For example, Article 21 of Constitution of India is widened. Like when you read Article 21 of Constitution, it just says right to life and personal liberty. But then what is life? What is personal liberty? In not many cases, a lot of interpretations were being given to this concept, where Supreme Court has said that right to life and personal liberty also includes right to privacy, right to travel abroad, right to clean air, right to education, etc. This means it is declaratory precedent. Concept was already there, but these specific things were not declared before that. It was declared in that certain given case. Okay, is it clear?
Yes, ma'am. Yes, ma'am.
So original and declaratory, original bringing something like totally new, declaratory something was already there. It's just that we have made it very clear and established. Next is authoritative and persuasive precedent. Authoritative precedent is which must be followed by judges whether they approve it or not. Like if Supreme Court of India says something, does not matter whether you agree, whether you approve that decision or not, you will have to follow that. Okay, take for example, Karnataka High Court has said that wearing burqa is not allowed in school. Okay, maybe there is Karnataka High Court who said like that, and you are a judge in a subordinate court. Maybe you are a judge in the Sessions Court, Karnataka Session, Bangalore Sessions Court. Okay. In such a case, even though you are against that decision, you feel what is wrong in wearing a burqa along with school uniform. School uniform just gives uniform for rest of the body, not for head. So there is nothing wrong in it. Even though you do not approve what Karnataka High Court has said, you will have to follow it. You don't have any option because you are subordinate to Karnataka High Court. Okay, that is called as authoritative precedent. As in, you don't have an option to see whether this decision is proper, not proper, whether to accept, not accept. You don't have an option. You will have to accept it. Okay, that is nothing but authoritative precedent. That is having its authority. Supreme Court's decision is authoritative precedent for all other courts in India. High Court's decision is authoritative precedent for its subordinate courts. Okay, is it clear? Are you sure? Is it clear or confusing?
No, ma'am, it's clear.
Clear. Okay. When we talk about authoritative precedent, it is having two different types: absolute authoritative and conditional authoritative. Okay. So absolute authoritative precedent must be followed without question, however erroneous it may appear to be. Even if you do not agree, you will have to follow it. You don't have any other option. Like take for example, Supreme Court's decision, all the other courts will have to follow. They don't have any other option. That is absolute authoritative precedent. It is absolutely binding. You don't have any other option. But what is conditional authoritative precedent? That means it is otherwise authoritative precedent only, but there is a condition. If condition is followed, it would be authoritative. If not, it will not. Okay, so what is conditional authoritative precedent? These are usually binding. However, the court can disregard them under certain circumstances. If some conditions are satisfied, you can ignore this decision also. For example, Supreme Court's decision is otherwise authoritative precedent. Supreme Court, what about Supreme Court's decision in Supreme Court? Okay, take for example, we need to consider how many judges has decided this particular case, right? Depending on number of judges, we say whether it is binding or not. That means number of judges is the condition. While considering whether a decision of Supreme Court is binding on Supreme Court or not, what we will see number of judges. That means we would try to see whether this condition is satisfied or not. Only if number of judges is higher, we would follow it. If number of judges was lesser, we can ignore it also. This is nothing but conditional authoritative precedent. It will be binding only if this condition is satisfied, otherwise we can ignore it. Is it clear or confusing?
Now it's clear.
Clear. Okay. So authoritative precedent is clear, right? Something which is having authority. You don't have an option. It may be absolute authoritative, it may be conditional. Another type we have is persuasive precedent. Persuasive as in those which the court are not bound to follow. As such, it's not binding, though they may take them into consideration while giving a decision. If you feel okay, you can consider. If not, you ignore it. No binding obligation. This is persuasive precedent. For example, High Court of Karnataka gives a decision that will have persuasive effect on all other high courts. If you feel okay, you follow it. If not, you give your own decision, no problem there. Okay, that is nothing but persuasive precedent. Decision of one high court will be persuasive precedent for all the other high courts because they are at the same level. Okay, so this is what different kinds are: original and declaratory, authoritative and persuasive. Authoritative precedent is further divided in two classifications: absolute authoritative precedent and conditional authoritative precedent. Okay, is it clear? Any point you want to be repeated? Example, anything?
No, it's clear. Yes, ma'am, it's clear.
Okay, fine. So this is a very important concept that you have. Okay, so there are some similar kind of questions like binding force of precedent and all that. These are same kind of only, little bit here and there different, like binding force of stare decisis and all that.